and I would like to call this meeting to order. And Ms. Nestor Jelen, if you would please call the roll.
Sure. Skip Daly,
Present.
Guy Loftman. Margaret Clemens.
Present.
Okay, we have 3 members in person and a quorum.
Okay, thank you. And would you be so kind as to introduce the evidence?
Sure. I request the following items be introduced into the evidence. The Monroe County Comprehensive Land Use Plan as adopted and amended, the Monroe County Zoning Ordinance as adopted and amended, the Monroe County Subdivision Control Ordinance as adopted and amended, the Board of Zoning Appeals Rules of Procedure as adopted and amended, and the cases advertised and scheduled for hearing on tonight's agenda.
Is there a motion to approve?
Second.
Okay, and just a reminder, make sure that your mic is turned on if you do make a motion, Mr. Loftman, sorry. Just make sure your mic is turned on. Yeah, it'll show green if it's on.
The right button.
There you go. Thank you.
Thanks.
So first and second, so I'll go ahead and call the roll for approval. So Guy Loftman,
Move to approve.
yes, okay. Margaret Clemens?
Yes.
And Skip Daly?
Yes.
Okay, motion carries.
Okay, and the agenda has been amended. And if there is a motion to approve the agenda as amended, I'd be grateful to hear it.
Motion to approve the amended agenda.
Second.
Okay, it's been moved and seconded to approve the agenda. Margaret Clemens,
Yes.
Skip Daly,
Yes.
Guy Loftman.
Yes.
Okay, motion carries.
Okay, and there are several minutes on the agenda for approval. And Mr. Daly has requested that to be able to have a little discussion. So Mr. Daly, I'd like to recognize you.
Thanks. I have 2 points of new business that I requested, and thank you for obliging, that get recognized prior to the approval of the minutes. One directly is impacted by that, and I will get into that first. I would like to make a motion that the Board of Zoning and Appeals, starting immediately and moving forward, no longer votes to approve the minutes, just the chair of the meeting requests if there's any amendments or changes that are required, and if he or she hears nothing, to just approve them.
I'd like to ask Mr. Schilling if that would meet with the compliance with the ordinance.
Yeah, it's my opinion at this point that the board has to approve its minutes.
But that can be done without a vote. According to Robert's Rule of Order and other county government offices do so, county council per se.
Yeah, I looked into that, Skip, when you asked me that, and it seemed to me that the board needed to vote on its minutes. But I'll look further if.
Okay, and regarding the minutes tonight, does that change anything as far as the minutes that are on the agenda for approval tonight? Mr.
Well,
Daly?
my motion requested that begin immediately, so
Okay,
I didn't hear anyone second. We heard some legal counsel that they'll look into it,
mhm,
but I don't know that that would impact our decision one way or the other at this point. I'm not sure.
okay. Is there a second for Mr. Daly's motion?
I'll second it.
And so would you call the roll on Mr. Daly's motion? Please?
Okay, so there's a motion and a second to have the Board of Zoning Appeals Chair approve the minutes without, if there's no remonstrance from the other members on the board. Is that correct?
Correct.
Okay, and it's been moved and seconded, so Mr. Daly,
Yes.
okay, Guy Loftman,
Yes.
Margaret Clemens,
No.
okay, so the motion fails 2-1.
The motion
Fails.
fails.
Since
Sorry,
you'll need all
I'm sorry.
three.
I would like to hear from Mr. Schilling. And I would like to entertain that motion at another meeting, but for the time being, not knowing it, I could not vote yes.
All right, my second point
Yes.
of new business is I would like to make a motion for the board to draft a letter over the coming days addressed to the County Board of Commissioners to request that they expedite their obligation to appoint a fifth board member.
Okay. Is there a second?
Second.
Okay, it's been moved and seconded to have the Board of Zoning Appeals draft a letter to the Board of Commissioners to request an expedited appointment to the vacant seat on the Board of Zoning Appeals.
Yes.
Guy Loftman,
Yes.
Margaret Clemens.
Yes.
Skip Daly.
Yes.
Okay, motion is approved, and I think we could do that offline and we'll be able to.
And I would be happy to begin that draft and circulate it to planning and legal to then circulate it to the rest of the board members.
Okay,
Thank you.
Thank you, Mr. Daly. Do you have anything further, sir? No.
I do not.
Okay, thank you. Thank you. And we move on, and there's no other administrative business listed. And so we begin with old business. And the first item on the agenda, did
so
you,
just to clarify, do you want to vote on any of the minutes tonight? Or is it that your opinion that none of them could be approved since we have three members and all three need to vote approve?
I think that we should all three be in agreement, and we should
Okay.
wait on Mr. Schilling's determination, and that we will reconsider this at the next meeting.
Question, if I may.
Yes.
Will that have any legal ramifications at this point to not have the minutes approved today? Is there a backlog? Is there something in the law that I don't know?
I'm sorry, I couldn't hear that question.
Would there be any negative legal ramifications tonight to not have the backlog of minutes approved? And while you're discussing this, I will apologize to those waiting patiently, but this is important to move forward. I hope you can appreciate that.
Yeah, I don't see that as a problem.
All right, great.
Okay, so
I will move to postpone the voting of that until we have our legal counsel advise us and our fourth member present.
okay, is there a second on his motion to continue the approval of the minutes till our next meeting?
Second.
So would you kindly call the roll?
Okay, so it's been moved and seconded to continue the approval of the minutes to the August BZA meeting, since the July meeting was combined into this month's meeting. Margaret Clemens.
Yes,
Skip Daly.
Yes,
Guy Loftman.
Yes.
Okay, the minutes have been continued to the next August BZA meeting.
thank you, Ms. Nestor Jelen. Okay, we move on to old business. The first item on the agenda is CDU-21-3, and this is a review of Bedford Recycling conditional use to Chapter 813 for central garbage rubbish removal, which was approved on September 1st, 2021, concerning a property at 405 West Dillman Road. And Ms. Crecilius, I see you're listed here as the planner.
Thank you, Margaret. This actually will be presented by Mr. Schilling.
Okay. So thank you, Mr. Schilling.
Thank you very much. And the packet has the statement of the position. that-
Mr. Schilling, could you please try to get a little closer to the mic?
Yeah, is that better?
Much better.
Thank you very
so
much. Yeah, the packet contains the sort of the history of this this issue, and explains why we're here today for a hearing. I think this is not a hearing to accept new evidence, because the issue is whether the BZA made an error of law based on the record on September 1st of 2021. So the purpose of the hearing is to accept a legal argument on whether or not the BZA made a mistake in granting a conditional use approval to Bedford Recycling for a central garbage rubbish collection facility. And the bases of the board's inquiry today is set forth in that packet. And I think at this time, if you don't have any questions, that the Bedford Recycling representatives could present their case. And then at the conclusion, the BZA can determine whether it made an error in granting the conditional use. And if so, it should revoke the conditional use, or if it concludes that it did not make an error, then it can affirm its original decision.
Okay, thank you, Mr. Schilling. So is Mr. Zeipold here or the petition? Thank you, Mr. Plummer. It's good to see you. How are you?
Doing well, thank you.
Good, thank you. Not with an attorney. We don't swear in attorneys. Yes,
Yes, my name is Dustin Plummer. I'm the attorney for Bedford Recycling.
yes.
Yes, thank you.
So would you just please sign in, and then you'll have 15 minutes to state your claims. We'll consider them.
Sure.
Thank
All
you.
right, thank you. I'll try not to take the whole 15 minutes by any means. I actually think this is, hopefully should be a fairly simple matter. The question presented in the packet indicates that potentially there was an error of law based on two reasons. One, that the proposed use did not meet the definition of a central garbage rubbish collection facility. And then two, potentially some question over the use of the term scrapyard and whether or not that is a permitted use within the context of the zoning ordinance. The board's initial decision was correct and should be upheld, is the short answer to the question. The confusion in this comes from the question of whether or not we're dealing with solid waste. And when you see central garbage rubbish collection facility, I think the mind initially goes to waste. However, further within the ordinance and actually within the definition, both recycled matter is referenced within the definition of what is a central garbage or rubbish collection facility. And furthermore, in the specific case of section 33, which was cited and incorporated as part of the decision, the ordinance is clear that this also includes a recycling facility. The testimony that was given at the initial hearing indicated that materials, recyclable materials, were going to be brought in to the facility. They would be sorted, processed, and then transported to another facility in part of the recycling chain. This matches squarely within the definition and the use that was granted and should be upheld. There is a question about, there was the term scrapyard that was used. However, I think the characterization in that testimony isn't important. What is important is what is happening at this facility. And what is actually happening at the facility, again, the collection of these recyclable materials, the sorting and the transportation to another facility for the recycling purposes is what's controlling. The confusion of whether or not it constitutes solid waste, I think, stems in large part from a definition of solid waste within the zoning ordinance, in this section of the zoning ordinance, versus solid waste as determined by, for example, the health department or the solid waste district. So letters were submitted during the presentation that both of those entities essentially said, we're not dealing in solid waste here. I think that is what prompted the question when it came to the writing the minutes and the justification of, well, wait a minute, if this is not solid waste, does it fall within the use? The board, in order to give meaning to all of the ordinance in section 33, when it talks about recycled matter and a recycling center, is necessarily required to view this, what is not solid waste under one part of the ordinance, as solid waste for purposes of this. If it wasn't read this way, the result of it would be that you could not have a standalone recycling facility in Monroe County. There's no other section in the zoning ordinance that's applicable that would work. And in order to give effect to all of the ordinance, which is what the law and what courts say we're supposed to do, is supposed to give effect to all parts of the ordinance if at all possible, the recycled matter is necessarily solid waste in the context of this section. Also, simply from a public policy standpoint, reversing the decision at this point in time, over 300 days after the initial grant, is going to create a lot of uncertainty and the inability to bring forth any planning matters. There have been tens of thousands of dollars spent for use that falls squarely within it, and that frankly is going to benefit the citizens of the county and provide another recycling option, which we see across the governmental entities within both Monroe County and the city of Bloomington as an objective and a goal of furthering green alternatives. That is exactly what this is doing. This is not something that the board, without very good reason, should be standing in the way of. And also, in order to overturn this, there needs to be kind of a clear air of law. It can't simply be a change in reasoning, which is what the proposed appearance, well, I'm sorry, what the proposal appears to do is simply change the reasoning to say what we said was recycled matter and constituted solid waste. We've changed our mind without anything in the record to do so. I think that's all I have, unless there are any further questions. Or
Does anyone have any questions for Mr. Plummer?
Does Mr. Schilling, is it appropriate for him to give a direct response before we ask questions, so we can hear what he has to say for Mr. Plummer, or is that out of order?
Can we pause the time
Yes.
and
Yes.
request
Well,
some
Mr. Schilling-
information from Mr. Schilling,
Yes.
and then
Yes, Mr. Schilling had presented what he, on behalf of the county. And at this moment in time, what we would do is ask for the public who would like to speak in favor of the petition, or the public who would like to speak in opposition to the petition. And then we discuss it among ourselves, and then we ask Mr. Plummer for a rebuttal.
that's fair. And
Yeah.
But this would also be when we'd ask Mr. Plummer direct questions,
If
or
you
would
have
we?
a question for Mr. Plummer, yes.
Okay, well, it's statutory interpretation is always confusing, where the rubber hits the road, and this is well, where the steel hits the recycling bin, I guess. As I'm reading the presentation we have from the county, this is the central garbage rubbish collection facility or private establishments contracted to remove solid waste from residential or commercial uses. We agree that's not what this is. That's not something that you all do. that your client does, right?
Well, I think the question is from that standpoint, is the recycled matters considered to be solid waste within that definition?
Okay, well, let me, I'm not saying that this is dispositive. I just want to see if
Sure.
there's, if there's what we agree on and it's, or what's agreed and what's not. And this is, so do I understand this facility does not under any circumstances remove solid waste from residential or commercial,
Yes, that's correct.
and it doesn't transfer waste to a locally operated landfill,
That's true. It transports it to,
another waste collection facility.
correct.
Okay, so you collect metals, ferrous metals?
Ferrous and non-ferrous both.
Okay, you collect metals, you receive metals and transport them to a waste collection facility, which is somebody who processes ferrous metals.
Correct. So it would be transferred to another facility in Bedford.
Where, and what happens there?
At that point, I believe that it is further sorted, shredded, and put into the recycling stream.
Okay, so that's a waste collection facility, it sounds like.
I believe so.
So you don't contract to remove solid waste, but you do transport to the recyclables to a waste collection facility.
Correct. And that's,
Okay,
yes, and that was in in, I think, Mr. Nuss's testimony further on, that was included in the packet as well.
okay, yeah, so the question is, public or private establishments contracted to remove solid waste from residential commercial uses. And so, if I am looking at this, there's the second half, which you all, I think I understand your argument why you need it. What happens to the first half about contracted to remove?
So I guess the other question is, what does it mean by contracted to remove?
Yeah,
Does that mean we have to send a truck out to pick it up? And
for instance, yeah.
for instance, or is it simply removing it from the stream? And for example, in the commercial uses, if someone comes and brings, if a commercial contractor were to bring metal to this facility, is it removing solid waste from the stream? I would argue that it is. And they will be paid for those materials, which is also arguably a contract for it.
Oh, okay, so now I'm looking at uses. Okay, you're saying that what's the source of these ferrous metals? How do they get there? Who's bringing them? Where are they from?
I think they could come from all over. So it could be contractors in a building, in a demolition process. It could be residential who are looking to discard, but in this case, actually recycle the metals as opposed to send them to the landfill.
But you don't, okay, so if a demolition company wants to bring their steel to you, that demolition company is contracted to remove uh, recyclable, it seems to me it's probably solid waste for commercial uses. And but your client is not contracted to remove them. And your contract is with the person who's contracted to remove them. You make a contract with them to pay them for the materials. And I say you, and I mean your client, obviously.
Right. No, I understand. I would say that they are being contracted to remove it. So these users are coming in with these materials, asking Bedford Recycling to remove them in exchange for a payment. And that is exactly what is happening. They no longer have to deal with those recycled matter any further.
Well, you can perhaps understand when I look at this, it looks like it's, Abe's trash hauling that brings things to a local facility, and it's your client does not contract remove solid waste from residential or commercial end users, but from people who haul it from that. Okay, I think I get the logic here
Sure.
of your argument, and it's helpful to me because I'm looking at this definition now. Section 33 is where is section 33? Have you?
So section 33 is a little bit more explicit, and I think I can point you to it. If you turn to page 7 of the packet.
Okay, now, the package. Uh-oh. I tell you what, my packet main,
Would you kindly put page 7 of the packet up on the screen for us to view? Thank you. It's.
Are you the only one missing it, Guy?
It's right before us now. It's on the screen.
got it.
Okay.
Okay, you're saying,
That saying within this section,
that
Recycling centers
let
are
me tell you, let me tell you what I think you think,
Yes.
and you can tell me if I'm missing it or
Sure.
if I've got it. Central garbage and rubbish collection facilities. And not to be, so you're interpreting, and not unreasonably, I'm not saying, and including, meaning and. So central garbage and rubbish facilities and recycling centers.
Correct.
That this expands from that narrower definition to a broader definition of that is recycling centers in general.
Correct.
Okay, I think that's two halves of the argument. I don't know how many other halves there are, but those are the two I was focusing on. I don't have any more questions.
Okay, thank you, Mr. Loftman. Mr. Daly?
Mr. Plummer, is it?
Yes,
Thank you for your time, by the way.
thank you.
I have a question for you. Have you, and you mentioned 3 different definitions within the county of Monroe of the term solid waste. Have you entered those into the record?
So really what I was referencing more are the letters that were exhibits at the original presentation, where we had a letter from the health department saying not solid waste here. And we also have,
So I'm sorry. So the letter from, looking at the letter from the Monroe County Health Department, and you're telling me that that says the letter that I'm reading is saying that if it's not solid waste, then XYZ. It doesn't define solid waste, nor does it tell me whether or not the health department classifies what you do as solid waste.
that's correct. Under the findings of fact from the previous meeting, it was noted in the, I apologize if you could give me just a moment. The solid waste permits that would otherwise be required from, for example, the Indiana Department of Environmental Management is looking at their definition of solid waste, saying,
Is that definition of solid waste, has that been entered into the record?
so I know that there was testimony at the prior hearing that said that Bedford Recycling presented evidence that no permits are required. Because really, when you get into Part G of Section 33, would state that Bedford Recycling is required to obtain all required permits from the Indiana Department of Environmental Management. Evidence was presented that no permits were required and no contrary evidence in the record.
And they determine that because you will be handling solid waste. And you apply for those permits because you will be handling solid waste.
No permits will be required because under IDEM standard, there will not be solid waste handled at the
Okay.
center.
All right. And that's what Mr. Nust testified to, that they would not handle solid waste.
Correct.
Now, you later say that the petitioner arguably used the wrong legal term. Which incorrect legal term did he use? And what would be the correct legal term?
And I don't even, to say legal term might be taking it too far, but there was reference made to the term scrapyard. And in the packet, there's a notation that referring it to the proposed use as a scrapyard is not included within this use. I would say that the correct term that should have been used was a recycling collection facility.
Okay, so the incorrect legal term was not solid waste.
Correct.
So you're saying that you will not be handling solid waste and that you are not handling solid waste. Is that correct?
I'm saying that they will not be handling solid waste as far as IDEM is concerned.
As far as,
IDEM, the Indiana
Yes,
Department of Environmental Management, However, when I read what the ordinance says, when it talks about solid waste, and it also notes that that could include recycled matter, I think they are handling solid waste within the term of central garbage rubbish collection
So it's
facility.
your testimony that you're not handling solid waste according to the IDEM, but you are handling solid waste according to the Monroe County Code.
Monroe County zoning ordinance as it's used in this section, yes.
Okay. I'm going to ask Mr. Schilling a question at some point here. I think that's all I have.
Thank you. Thank you, Mr. Daly. Thank you, Mr. Plummer. Thank you.
Thank you.
Are there members of the public who are here who would like to speak in favor of this petition? If so, come to the podium and sign in, and then we'll swear you in, sir. Would you please state your name?
My name is William Bankert.
Mr. Rademacher?
Bankert?
Bankert?
Yes.
Would you please raise your right hand, and do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Yes, okay, so well, you have 3 minutes to speak on behalf of this petition.
Okay, my family, we own the property at 101 West Dillman Road,
Mhm.
which is very close to this proposed facility. I'm in favor of it as a steel recycling facility, which is what it's going to be. I don't know about the definitions or anything that you guys are arguing about, but I'm much in favor of having that facility. We need another facility like that in Bloomington.
Okay, thank you.
Okay, welcome.
Thank you so much. Is there anyone here who is going to speak in opposition to the petition? Is there anyone online or on Zoom or who is calling in who would like to speak either in favor of the petition or in opposition to the request? If so, please raise your virtual hand on Zoom or press *9 on your telephone. We have 2 hands raised. So can you tell me or recognize them?
The first one is Mr. Cranley and the second one is Jason Fegans.
Mr. Cranley, welcome. If you could unmute yourself.
I believe I am unmuted. Hopefully you can hear me.
And would you, yes, we can hear you. And would you please raise your right hand, and do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
Thank you, Mr. Cranley. So you have 3 minutes to make your testimony.
Yes, thank you. I am counsel for Republic Services. I've spoke before in opposition to some of the proposed changes at this site. We are neighboring property. We support the petition to withdraw the conditional use, basically for the reasons that Mr. Schilling said in his submission in the packet, that just simply doesn't fit as a matter of law, the definition. We see the definition in it. I don't want to belabor this. I think it's already been gone over quite in detail, but it's a central garbage rubbish collection facility requires a public or private establishment contracted to remove solid waste from residential or commercial uses and transport such wastes to locally operated public or private landfill. They are not removing under contract solid waste from residential or commercial uses. It's a scrapyard. I think, as complicated as statute interpretation can get, this one is of common sense that does not fit that definition. And Mr. Plummer's doing he's a good lawyer, and he's doing what a good lawyer does, trying to find a way to fit this round peg to fit in a square hole. But at the end of the day, he acknowledged very candidly that this isn't a situation where people are being contracted out to go take materials from residences or businesses and bring them to this place. It is somewhere where people are bringing scrap metal. We can discuss the need for recycling facilities. There was already a discussion in an ordinance revision proposed that did not pass. That's a policy issue for a different day. What we have to do here today is apply the plain language of the ordinance, and it simply does not fit. So with that, I'll go ahead and cede the rest of my time. Thank you very much for your time today.
Thank you, Mr. Cranley. Thank you. And the next person?
Jason Fegans.
Yes, I own the adjacent property right next door.
Mr. Fagans, if you don't mind,
yeah.
would you please raise your right hand, and do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
Thank you. And if you would be so kind as to begin again your testimony?
No problem. I own the property just adjacent to this, just to the, I guess it'd be to the east. And I like Mr. Bankert, I want to put my support in. Bloomington needs more recycling facilities, and Republic Lawyer is doing what Republic Lawyer does and try to squish it. They do that kind of coast to coast to kind of eliminate competition. And I want to be, as a resident of the county, I want to say we need more competition, not less.
Is that all, Mr. Fagans?
That's all. I'll see the rest of my time.
Thank you very much. Is there any other member of the public who is here to speak in favor or in opposition to the this case? If so, please raise your virtual hand on Zoom or press *9 on your telephone to be recognized. If none, then we go back to Mr. Plummer for a 3-minute rebuttal. Is it 3 minutes or 5 minutes that he has?
I believe it's 5 minutes.
So you have 5 minutes, Mr. Plummer, to make a rebuttal to the arguments made.
Mr. Schilling going to present anything, or?
I think he did. Mr. Schilling, did you have anything more you'd like to present? Yes, thank you, Mr. Plummer. Yes, Mr. Daly.
Mr. Schilling, and I suppose I'm seeing two issues here that are being addressed that are screaming out to me in this letter. One of them being that the BZA is required by an actual error of law, not simply a change of reason. And he quoted a precedent of Esrock Cement Corps v. Clark City. Did we reverse this in a manner of finding an actual error of law, in your opinion?
Yeah, I think the case goes on to describe what an error of law is, and that is taking the facts and misapplying them to the law would be an error of law. So, and the notion is that there's a definition of central garbage or rubbish collection facility in the zoning ordinance, and that is the law. And the facts that were applied to that definition is about waste. Garbage is defined as waste from household food preparation. Rubbish is defined as trash and other things from basically household use or business use, whatever. So it's all about waste. It's about collecting waste, transporting waste, and then disposing of waste. And so.
But you believe, sorry to interrupt you, but you do believe that there was an actual error of law and we've complied with the legal precedents to first overturn this, or else it's moot.
That is your ultimate decision tonight. But when we met preliminarily, the BZA concluded that they'd made an error of law.
And you stand by that?
I do.
As legal counsel to this board, you stand by that?
I do, and I'd be happy to explain.
Okay. My next question, if I may.
Yes.
Attorney Plummer mentioned a disparity between the definition of solid waste in accordance to the Monroe County Health Department, the IDEM, and our zoning ordinance that is applicable here. Do you agree that there is such a disparity in the definition? And could you follow it with, is there a possibility that Mr. Plummer's definition of what his client is doing could fall under that disparity?
In my opinion, no, and I don't believe there's a disparity. There are no definitions of solid waste in the zoning ordinance, but the zoning ordinance is part of the Monroe County Code, and Title I of the Monroe County Code talks about definitions and so forth, and says, and as does the zoning ordinance, basically says if the term is not defined in here, it will be given its technical meaning at law or its plain and ordinary meaning. And the technical terms for solid waste are defined at law by the IDEM. And our health code, chapter, what I think it's 360, incorporates the state definitions for solid waste and solid waste facility and so forth. So to me, there is no disparities. Solid waste is solid waste.
Thank you.
Thank you, Mr. Schilling. Mr. Daly. Mr. Loftman, do you have any questions for Mr. Schilling?
I think in responding to Mr. Daly, you said you could give an explanation of your concerns, and he proceeded with other questions, but is there anything else you think that we should understand?
Well, I think I would respond to the condition 33 mention of a recycling facility. And it makes sense to have that in there actually, because when you're bringing garbage and trash from a home or a business to a collection facility, they frequently have source separation operations where you have a bag of trash, you'll pull out the aluminum cans, you'll pull out the plastic and the recyclable materials that have been collected in the trash, in the waste. So you're removing that from the waste stream. So it makes sense to have that recycling in there. And the question is that different than a facility that is open where people can drop off metals, which in the original hearing, Bedford argued, and I think correctly, that those metals are not waste because they're not intended to be discarded. They're intended to be sold. They have value. So that was, I think, the thinking that brought the BZA to preliminary conclude that this wasn't a waste facility because it in no way involves waste.
Well, today Wednesday happens to be my dump day. And I took my aluminum cans down to the Dillman Road and I put them in the aluminum recycling, and my understanding is the county sells those.
But you didn't.
Yeah, no, I didn't. Oh, okay. Are you saying the fact that the petitioner, is getting that they're paying people who bring them things is an important distinction?
Yes. That there's no abandonment of a material. There's no discarding of a material. There's a sale of a material as opposed to a discarding.
And potential, yes.
And that sale means it's not a central garbage rubbish collection facility. What part of the ordinance says that removes it from being central garbage rubbish collection?
Because there's no contract for the collection and transportation of waste. Waste is taken there and sold, and it's not waste because it's being sold. It's a valuable product.
By this definition, the Dillman Road that I go to is not a central garbage rubbish collection facility.
I would say it would be. It just has a source separation component to it. But the primary purpose is to collect trash.
Trash and waste.
And what differs from this proposal from, let's say, other competitors that do purchase recyclable materials?
To the best of my knowledge, those are located within the city of Bloomington.
So, okay.
Yeah, if I might, when opportunities are made for the purchase of undesirable metal waste that needs to be translocated to another environment for further sorting, processing, and ultimate disposition, the price can be related to perhaps the volatility of the metal, I believe. Isn't that true, Mr. Schilling?
Yes.
Yes.
So you're suggesting that there's no other business that operates doing what they're doing within the county line?
I'm not aware of any scrap metal facility in the county.
No.
Within the city limits, yes.
Okay.
So are you finished with the
Sure.
questions? Yes.
I've still got,
Yes.
let me get to something that hasn't been talked about, which is right now, are they doing this that they got permission to do? Did they act on this and they've been transporting metals, receiving and transporting metals, or they've never begun to actually do this?
I don't believe so.
They haven't begun to actually use this. Have they? I'm looking for reliance interests, which has not been talked about in it, but I'd like to know, have they based on this decision going on a year ago, have they gone in and bulldozed the site and set up any facilities, or is it basically in the same condition it was in?
Well, I don't know, but I know that within 30 days of the decision, Republic filed a petition for judicial review. So within a month of the decision, everyone was aware that this issue, that the decision would be challenged in a court.
Okay. Is it appropriate, and it may well not be, to inquire Mr. Plummer whether any action in reliance on this has been taken on the ground?
Well, I would have to defer to Mr. Schilling to answer that question, because that's a legal question about whether or not.
And I
Mr.
know the
Bachman-
record's closed, which makes it more difficult,
Yeah.
but
Yeah, I mean, I don't think it's relevant to the decision tonight, but if you want to hear it, that's up to you.
I would like to know if it's appropriate, whether they've been acting in reliance on this in setting up a facility to do something, and now we're saying, no, you can't.
Well, Mr. Plummer has 5 minutes to rebut and to answer the questions
Ah,
that have been
great,
raised.
okay,
So if you're finished with the questions for Mr. Schilling,
I am,
then
thank you.
Mr. Plummer, you have 5 minutes. Thank you.
Thank you. Just a couple points and I'll start. There has been additional work, mainly on the engineering side. There has not been any building or massive site preparation because there has been a lawsuit filed and then subsequently received notice that the board was considering potentially overturning their decision. I think the issue with some of the things that have been indicated, the idea that rubbish and that garbage are all residential uses. One ignores the fact that we talk about commercial uses right in the ordinance. And it also fails to take into account the fact that recycled matter is also explicitly included in this statute, or in the ordinance, excuse me. If the board overturns its conditional use permit, what it is effectively saying is that nowhere in our zoning ordinances is there an ability in the county to set up a recycling facility only where matters can be taken. And you also have to take in trash, rubbish. We want a dirtier use before we're going to grant this conditional permit would be the effect of the decision. Ignoring the fact that can be recycled matter is different than rubbish. It can be not solid waste. It can be recycled matter. They're two different things. The ordinance contemplates that. And I believe that the proposed use meets those conditions and that the board was correct when it granted the conditional use permit initially.
Thank you, Mr. Plummer.
Thank you.
Thank you. So we come back to the Board of Zoning Appeals for discussion and or a motion. I'd like to add one item to our discussion that, I was serving on the Board of Zoning Appeals when this case was heard before. And I can say that I did not understand completely the definitions. And I think that my vote would have been different had I understood the definitions more clearly. So I just want to state that. And
Well, let me make, did you vote for the decision that's now
yes,
going to be reversed?
yes, that might be reversed. depending upon-
That is suggested we
Yeah.
reverse.
Can we get can planning share with us the original votes and then the votes to recall the decision?
Sure, I can
Is
pull
that
up the vote.
fair? Well, I think that will address what you're asking.
Okay, it looks like it was,
Mike, please.
oh, sure. Can you hear me better now? Okay, so the vote was 3-0 on the vote of the conditional use. There was one abstention. And so the votes in favor were by Mary Beth Kismarchek, Vicky Sorensen, and Margaret Clements.
And then there was another vote, if I understand, to reverse that decision that's already occurred.
At the December 15th, 2021 Board of Zoning Appeals special meeting, there was a motion allowing the board to schedule a public hearing on case number CDU-21-3, give notice to all interested parties to determine whether the board erred as a matter of law by concluding that the use proposed by Bedford Recycling, Inc. was a central garbage rubbish removal collection facility for which a conditional use could be granted, carried unanimously 5-0. So that was voted by Margaret Clements, Bernie Garitas, Skip Daly, Mary Beth Kismarchek, and Vicky Sorensen.
Thank you.
So is there a motion?
One more question for staff. It appears to me that tonight we're not posed with whether or not we all of a sudden feel as if this is an approved use. It appears to me as if we are voting to whether or not there was an actual error of law and whether or not we believe our vote in December was a valid decision. Because those seem to be two separate matters to me.
Well, I guess the issue for the BZA tonight is whether you made an error of law on the September 1st, 2021 decision. If you did, then your action was ultra various, which means be beyond your power and would be void. If you conclude that you did not make a mistake, you did not commit an error of law on September 1st, then you would affirm that decision.
If we have a non-unanimous vote, what is the effect of that? Assuming that somebody moves to overturn it, which nobody has yet moved. Nobody moves to overturn that. Am I correct? Nobody has moved to overturn that decision. None of the three of us.
Yeah, if nobody moves to overturn that decision,
Or if that motion fails, if it's
if
made.
that motion fails, if the motion fails, then no action has been taken on this issue.
And the original September decision would stand.
Would stand, but the question is still out there. Because if it's not unanimous, you couldn't approve it or deny it.
So it stays in limbo until a unanimous decision is made, if it ever is.
Yeah, I would say so. You know, I guess the decision was made in September. And I guess that is still an effective decision until it's repealed. Let me put it that way. So if nothing happened, no final action is taken tonight, the question is still out there. It would just be status quo.
Would it be appropriate for a member to move to uphold that decision? The September decision,
Which decision?
the September decision that said, go ahead and do this.
If the member felt that there was no error of law, that would be appropriate.
Okay. I move to affirm the September 1st, 21 decision in this matter.
Is there a second?
Looking at me. I am not going to second that because I feel tonight's obligation is to overturn the most recent decision. And I don't believe in good faith that we can overturn the December decision.
Mr. Daly, is that a motion to overturn the September decision?
I think it's,
Pardon me.
is that a motion?
Because we were in error. Because the Board of Zoning Appeals made an error. That-
I'm suggesting I've not heard evidence that the December 15th decision could be overturned. Does that answer your question?
Well, I heard you. I'm not allowed to make a motion because I'm the chair, right?
You can make a motion.
I can make a motion.
Sure you can.
Yeah, and just to clarify, Mr. Daly, the vote in December was to schedule a hearing tonight to
Right.
review the case. So just the meeting in December was a special meeting to re-review this case at tonight's meeting. The September decision was the decision to grant the conditional use.
So you're suggesting that the December was not the board suggesting there was an error?
It was a vote to schedule a public hearing in the event that the board assumes there could have been an error of law, but tonight's vote would be to affirm or uphold the decision, or sorry, to retract the decision or to uphold the decision of the September BZA meeting.
Well,
Margaret, do you have a motion?
I do have a motion, but I know Mr. Daly's in the
I'm
middle.
not, what I'm suggesting is I don't think there's been enough evidence presented one way or another to overturn. And if the current suggestion is that this is approved, then was that your motion?
Yeah,
To maintain the decision?
to maintain the September 21st decision. We've now heard argument on what, as decided in December, that we should hear argument on it, and we've heard argument on it, and the arguments are well presented and
It's not one way or the other.
but if the arguments aren't convincing that there was an error of law made that should be or needs to be overturned, then I think we should stand by the September decision.
That's what I'm suggesting. I don't think there's a case made to overturn one way or another, and I believe we have to maintain with the decision. And if you're suggesting the decision, the most recent decision was from September, then yes. I will second your motion.
Okay,
Okay, well, I still have a motion, but Mr. Schilling has a comment.
No, just to make it plain, in September 1, 2021, the BZA moved to approve a conditional use. In December, the BZA concluded that it was likely a mistake had been made and that the matter should be rescheduled for rehearing, which is today.
So
Okay.
I'm going to, because I was here both in September and in December, and I believe I made an error in my vote. And I think that it wasn't clear to me about the rubbish waste removal delineation versus scrap metal sorting and processing and the different complexities that go into lines of business that could result in possible environmental damage, that I would like to move that the Board of Zoning Appeals revoke its affirmative decision from September 1st, 2021 concerning case number CDU-21-3. And this is a reconsideration of an original decision due to the fact that I believe, at least for myself and on behalf of the Board of Zoning Appeals, that we were in error. And so that's my motion. If there's a second, fine, and if not, fine.
I'm going to second that motion. And I will address the situation when it's appropriate for me to do so, the overall situation.
Okay, thank you.
Okay.
So
It's
you can
been-
call the vote.
Well, I'd like to discuss it a little bit more.
Okay, well, I would affirm his discussion of that. You know, I withdraw my motion, I guess, and will entertain further discussion.
Yeah, that if a mistake was made on September 1st,
Yes,
that is unfortunate. But the argument, and on its face, it's as the one person from the public said, it doesn't look very good for overturning, for granting this because it's not, doesn't meet the obvious plain definition. I get the argument saying a mistake was made and that no mistake was made because you can take this language and line it up just so. And I don't think it's been an unreasonable argument. And I was willing to buy it. But I also think it's important for us to be able to make decisions and not leave things undone. So I'm willing to reverse that decision. Otherwise, we're going to leave this in limbo. So I'm going to support your motion because I'd like us to be decisive in difficult situations. And while I can see it either way, I'm willing to go either way because I'd like to see us make a decision.
and just to further clarify this, Ms. Nestor Jelen, could you fill us in a little bit, and the other members of the Board of Zoning Appeals, on the any of the cases that have come before the Plan Commission and the commissioners on the Board of Commissioners on this particular project, or is that not something we can do in the Board of Zoning Appeals?
Are you talking about any subsequent petitions related to this?
Yes.
I would say that I would regard that as irrelevant to the
Okay.
question today.
Okay.
But
Okay, thank you. And one last item, as we're discussing it, in the notice that was given originally for the September 1st meeting, was the address listed correctly?
I think we reissued them even back in September.
Okay.
Before then, with the east change to west.
Okay, thank you. Okay, so, so for me, and for me, what I came to understand, which was something that I was not well steeped in before, and that is the intricacies of waste processing, scrap metal processing, and various values for that, and the economy related to that, and what potential ramifications it could have for our county and for our environment. So I gained new appreciation for the complexity of the zoning descriptions and how precise they are. And I did not understand that before this case. I can just say that myself. So I would like to, again, make a motion if people
Well,
are ready.
You made the motion and I
No, I
seconded it.
withdrew it. I withdrew it so that you could
Oh.
speak. Yeah,
Ah,
yeah.
okay.
So in case number CDU-21-3, reconsideration of an original decision concerning Bedford Recycling, I move that, that we vacate the September 1st decision, because I believe, at least as for myself, I was in error in the approval.
Second.
Okay, there's been a move and a second, a first and a second, in order to revoke or to vacate the decision made by the Board of Zoning Appeals for CDU 21-3, voted on September 1st, 2021, on the basis that it was an error of law. Guy Loftman,
Yes.
Margaret Clemens.
Yes.
Skip Daly,
I believe one of the few times the NFL has it right is when a red flag is thrown, there has to be irrefutable evidence. And I don't believe enough of a case has been made to overturn this board's decision. I didn't think, had originally thought that that decision was already made, and I didn't feel there was enough evidence from the petitioner, but I vote no.
so the motion fails 2-1, and you can make another motion, or the case would automatically go on to the next Board of Zoning Appeals agenda.
I think we've tried it, we flipped it, we flopped it. I don't think there's another motion to be made on this, but I'm willing to entertain one if anyone has one.
No, I
Okay.
think perhaps at the next meeting, we'll have 5
Yes.
or at least 4. And if we have to go through this all again, we have to go through this all again. And then maybe the 4th and 5th people will help us come to a final decision.
Okay, thank you, Mr. Plummer. Thank you, Mr. Zeibel. Thank you for coming and taking your time tonight to share with us your arguments.
So that case will be heard at the August 3rd Board of Zoning Appeals meeting.
August 3rd. Thank you. Okay, moving on, we have a variance. It's BAR 22-16, Naylor front setback variance to chapter 804 concerning a property in Bloomington Township at 5959 North Hudoff Road. And the owners are Sean and Jennifer Naylor. And Ms. Behrman, you will be presenting this case.
Yes.
Thank you.
All right. So in summary, we have, I get 2 mics. Okay. We had a permit filed R-22-431, and it was to expand an existing 1977 residence about 16 feet to the south. This was going to give them an additional 433 square footprint addition, or approximately 800 square feet in total of new residents. The property is zoned Ag RR, and when there is no direct frontage in that zone for front setback, it is 50 feet. We had to decide what the front yard was for this property, and we used the definition in chapter 801. Basically, we have to use where the foundation of the house is closest to a specific road. And this road was built after this house was built. So the house was built in 1977. A new road went through in 1996, known as Paddock Ridge. It's a local road that is maintained by the county. And now I'll show you some pictures that kind of demonstrate what I'm talking about. So
I'm sorry, can you try to get right in the mic?
sure. Yep. And so this property is technically located off of North Hudoff Road. If you see my cursor, this is the driveway for the property, and they're addressed off of this North Hudoff Road. However, in 1996, there was a subdivision that created Paddock Road, which goes right next to the petitioner's house here. And we had to determine that the northern property line was the front, what we would consider the front yard. And so Because of that, and it's not got direct frontage, because there is a little small strip of land here that was not obtained with right of way. They are encroaching 26 feet into a 50-foot setback. Had there been direct frontage along this property line, they would have been encroaching 1 foot. This is the plat for the Siffin subdivision. And you can kind of see this yellow square designates the petitioner's home, and they'll be expanding to the south. This lot was not a part of the subdivision, just happened to be next to the subdivision. This is the petitioner's home. So the left-hand picture is where they will be doing the expansion. And then the right-hand picture is Paddock Ridge, the road. And I put a circle around the petitioner's home. You can see they have a screen of evergreens right there. So it is kind of even difficult to see the home. This is their site plan that they submitted as a part of the building permit application. And so again, they're demonstrating this existing home, showing that they're 24 feet off of the property line. And then this is the expansion. I just included some information demonstrating that the septic system location should not interfere with their proposed addition. The swimming pool has since been removed. And then the petitioner submitted a 4-page letter, and hopefully you had a moment to read through that with their reasoning as to why you should support this variance for a front yard setback. And I did include all 4 pages here if anyone wanted to reference that in the presentation. So staff makes a recommendation for VAR -22-16 for the front yard setback variance. We recommend approval because the Siffin subdivision recorded in 1996 somewhat allowed for that 1977 built residence to become a pre-existing non-conforming structure. And as such, this constitutes practical difficulties to the property owner with regards to meeting the front setback requirement. Does anyone have any questions?
Do you have any questions?
No.
Okay, is the petitioner here, the petitioner's representative?
I think they are online.
Okay. And would that be Ms. or Mr. Naylor?
It would be Jennifer or Sean Naylor.
Okay. The petitioner has a total of 15 minutes for their presentation. And if you could be unmuted and also raise your right hand. And do you swear to tell the truth, the whole truth, and nothing but the truth?
Can you hear me?
Yes, and so is this Sean Naylor?
This is Jennifer, but Shannon's right here.
It's Jennifer Naylor?
Yes.
Okay, thank you. Will you please, you can state your case to the Board of Zoning Appeals.
Well, I would say that Ms. Burden covered pretty much the whole story. I mean, we purchased the home just 1 year ago and are just looking to add on some extra living space and an additional bathroom for a family of 4. It's a single bathroom home. None of our neighbors have any concerns or complaints. We have good rapport with all of them. None of them would be able to see the addition from their own property. And like she said, the addition is on the opposite end of the home from where the setback is. So we're happy to answer additional questions though. As well.
Okay. Do any members of the Board of Zoning Appeals have questions for Mr. or Ms. Naylor?
I do not.
I do not. Well, if that's all, we'll take other comments from the public. If there's a member of the public here who would like to speak in favor of the petition or online, please raise your virtual hand or press *9. And if you're here to speak in opposition to this request for variance, please raise your virtual hand, press *9, or come to the podium. And if there's none, we come back to the committee for further discussion and/or a motion.
I'll make a motion.
Thank you, Mr. Daly.
I make a motion in case number variance -22 -16 that the board affirms the approval of the planning staff for a front yard setback variance to chapter 804.
Second,
Okay, it's been moved and seconded to approve the Naylor front yard setback variance to chapter 804. This is case number VAR -22 -16. A vote yes is a vote in favor to approve the front yard setback variance. Margaret Clements,
Yes.
Skip Daly,
Yes.
Guy Loftman.
yes.
Okay, variance passes 3-0.
Thank you so much.
Thank you, Ms. Naylor. Okay, we have two variances that are next on the agenda. That's VAR -22 -17A and 17B. And it's the Seagull buildable area variance to chapter 804 and the Seagull Eco Area 2 variance to chapter 825. And this concerns the parcel in Clear Creek Township at 3130 East Will Souders Road. And Ms. Crecelius, will you please go over this with us?
Thank you. Okay, so the petitioner is requesting two variances, so they're both from slope restrictions. The first, the buildable area, which is the 15% slope restriction for structures. The second is from the Eco Area 2, that is the 15% slope restriction for structures and also for any land disturbance at all. Okay, so the property is currently zoned agricultural rural reserve and also Eco 2 and Eco 3. The purpose of the two variances is to allow for the existing unpermitted single-family residence to receive an after-the-fact improvement location permit. The property is 5 acres. And it currently contains a single-family residence, a decommissioned manufactured home that was formerly a residence, and an accessory structure that's a detached garage.
I'm sorry, but if you could just be a little closer to the mic, it'll help me.
Absolutely.
Thank you.
Okay, so the property owner advertised the property for sale and a potential buyer had contacted the planning department regarding compliance with the zoning ordinance. The zoning inspector identified that the single family dwelling was originally built using the log cabin rule somewhere between 2005 and 2010 based on aerials. And that it has continued to be expanded into steep slopes as recently as this year without an improvement location permit. Now, the log cabin rule specifically excludes building codes from applying to private homes that are built by individuals and used for their own occupancy. The log cabin rule is not exempt from the improvement location permit requirement of the Monroe County zoning ordinance. So anytime you get a building permit, you are also getting an improvement location permit in with that, which is issued by the planning department. So, let's see. So the ILP was never sought or granted, so an open enforcement case, was started and the petitioner has now sought to kind of remedy the situation. There have been after the fact ILPs granted for a detached accessory structure. They have decommissioned the existing manufactured home that was a residence and now it is just another accessory structure. Okay, so the location of the main two-story house of the residence is in an area that exceeds 15% slope for structures and 15% slope for any land disturbance within the Eco Area 2. So if the variance is approved, the petitioner will continue with the ILP application for the two-story house to be permitted as the main single-family residential unit. That does not include a building permit. That is only the improvement location permit issued by the planning department. There are issues regarding the existing one-bedroom septic system that is connected to the residence. We hope to address those during permit review. There's been a verbal acknowledgement that the health department agreed with the transfer and connection from the mobile home to the two-story house, so we will be seeking something put in writing or something input by the health department. So if the variance is denied, planning staff in coordination with county legal department would require that portions of the single family residence that's encroaching into the 15% slopes be removed and that the site be remediated. So on the screen currently is a certified site plan done by Deckard Land Surveying where we can, it's a little difficult to see, but this pink line that goes kind of across is what's identified as possible septic is just touching the two-story house, kind of goes underneath this gray square. So it appears that a good majority of the existing structure and decks is located in areas that exceed 15%. So this was the original for sale advertisement that went online. We could see just a little bit more information. They advertised a 2-bedroom, 1-bathroom mobile home as an additional residence. Of course, that's now been decommissioned. Here are pictometry photos from Eagle View or Elevate GIS going from 2017, showing the expansion of the back deck from 2017, expanding down to a 2nd story in 2020, and then part of that deck then being covered this year. So the property owner and petitioner has included a letter to the Board of Zoning Appeals. They state that the original owner did not seek the improvement location permit and built the structure due to lack of knowledge and sophistication. On the bottom right is a pictometry photo of the property that is from 2022, so this year. The next few round of photos are going to be from the most recent staff site visit. So the blue house in the front is going to be the primary dwelling if approved. And farther, the second photo on the left, on the right, we can see the detached accessory structure, the carport, and also the mobile home. This is the kind of the area that's located on the western side of the property that was originally identified as kind of a possible septic area. It's a not confirmed information as to what this septic system is. There's some information that states it might be a holding tank. We do not have enough information to know what the capacity is or what the status is. So included here in the presentation, and you also received these printed, are also just 2 letters that were submitted to planning. I believe both of these are in remonstrance of the variance requests submitted by, I think both are adjacent neighbors, adjacent property owners. So you have those printed as well as here on the screen today. These are photos that are included with the last letter from a Mrs. Siphon. So staff is recommending denial for both variances 17A from the buildable area requirement of Chapter 804 and also 17B from the eco area to requirement of Chapter 825. Does the board have any questions?
Mr. Daly, Mr. Loftman.
I'm a little confused. There's the non-complying structures were built by Mr. Sego.
Yes.
Okay. But Mr. Sego, is Mr. Sego the current owner?
Mr. Sego placed the property under an LLC called Sego Holdings.
Uh-huh.
And it appears that the current property owner, the petitioner, Ernest Yee, now owns Sego Holdings LLC. So the original builder is not the current property owner.
So in the introductory materials, it says a potential buyer inquired as to the zoning. That's not Mr. Z or that's some new person who's come in. And
I'm not sure who it was. Whenever a property goes on the market, planning gets many calls on it. So.
I'll ask those questions.
Okay, fine. We'll wait and Mr. Carmen will address them.
Do you have any questions, Mr. Daly?
I will wait until the petitioner
Okay.
speaks.
Yes, please come to the podium and state your name, and we're glad to hear. Thank you for your patience tonight.
My name is Mike Carmen. I'm an attorney representing the petitioner, Siegel Holdings LLC. Aside, I'll get into the merit. Let me answer those questions first. Just a little bit of history. I'll try to be brief on this. So part of the improvements on the property go back to prior owners, go back to two owners back. They sold the property on contract. And in 2003, that contract was assigned to Randy Siegel and his wife, Kim Siegel, and they became the contract buyers. Mr. Siegel then is a builder. He's not a developer. He's not the general contractor. Most of his work has been working for other companies, other contractors. He was for sometimes worked for Value Built Construction. That's Ernest Zai's company. That is the general contractor. Has done a lot of home development, more in Greene County, Owen County than in Monroe, but he's been in the area for a number of years. And Randy Siegel has been a very valuable part of his work. And so they bought the property in 2003, and Randy built the single family home structure. He tells me he thought he finished it in 2005. I say that because the property record card suggests that the year of construction for the single family home was 1998, and he says that's wrong. He built it, and that was after so we attribute the year of construction of the single family home 2005. Then more recently, he's added a little bit to it. You've heard Ann's recitation that he added deck and deck porch, whatever you want to call it, on the backside primarily. Then he and Kim have moved to Brown County. They are marketing the property. So a potential buyer, not anybody associated with the property now, but third party, was looking to buy the home and apparently came to planning, investigated some zoning questions on that, and learned that's when all this was uncovered, that the complete lack of permits, the building permits, is a separate issue. So that buyer's out of the picture. But that surface issue, Rachel Henry ends up coming out to the property, zoning inspection, does a notice letter of zoning violations, non-compliance. So Randy is still working for Value Built Construction and Ernest Zai. Randy, don't mean to throw him under the bus, sorry. Randy's about 61 years old. He is not capable of dealing with these issues. That's not a cognitive problem. He just, he's too old in the tooth to figure out what's going on. He's not even connected to internet. When I talked to him, no smartphone. He isn't capable of filing the petition. So Ernest Zai formed Siegel Holdings, and he bought the property from Randy and Kim Siegel. And that's where Siegel Holdings, he named it after the company, after Randy, frankly, as a show of respect, because he's valued him as a labor contractor working for him with Value Built Construction. That's how we ended up with Siegel Holdings LLC owning the property, because they bought it with full knowledge of these issues from Randy and Kim, and Ernest Zai through Siegel Holdings now is trying to clean up the problems. That's who is now moving forward on trying to pursue the after the fact ILP. That's who has worked with planning. They've had some agreement. They've essentially, I call it decommissioned the manufactured home, the trailer, remove the kitchen and some other facilities out of it. So it's not a habitable structure any longer. So to get rid of that second residential structure on the same legal lot, because that was a problem. So they decommissioned that and make it really just a accessory storage building at this point. So now we're back to the home itself and the additions that Randy's added to it through the deck, the porch and stuff on the back, I'll call it the back side of it. And he did that work without a building permit. Now, he did it at a time that he was an owner, and that we get the log cabin rule. And I know, and we've confronted this before here and other places, that is going to continue to be a problem in the sense that many people, and I'm going to put Randy in that position. I don't represent him as such. I called him and say, what happened? What'd you do? When'd you do it? Why'd you do it? Trying to figure out history, how we got to where we are. And it's pretty clear to me in talking to him that being exempt from building permit, which he knew that very well. He had no question on that. Of how that worked. But I saw in him what I've seen too many times, and we're going to continue to see, is being exempt from building permit means you're exempt from permits. And that does not apply, as Anne's already said, to the ALP. It wouldn't apply to some other permit requirements. It only is an exemption by state statute from a building permit requirement. It actually only applies in counties. It doesn't apply within the corporate limits of the city or town either. It's a county regulated issue. So he literally, in his statement on RSI, referred to him as being unsophisticated. That's what he meant. He didn't fully appreciate what he was doing and since what permits going to be required, and nor did he ask. That's very clear. He thought he was exempt from building permits, which means he's exempt from any permit requirement. He built the structure and he does a good job. He does good work. That's why Ernest likes him and is trying to keep him. So we're confronted with a problem. Were variances required or don't build the structure? Absolutely. The building permit did not exempt him from those slope issues. And I know it says 2 variances, but it's a rare case if you're ever going to see one where those don't go in tandem. If you've got those areas in the county where we have slope restriction problems, are rare going to have a buildable area, enough buildable area. You're almost always going to have the same. You don't always see these 2 problems at the same time. Probably this is another case of it. So I say it's a problem because there's not a good answer on this. You know, there are a couple of neighbors who have filed letters. You've probably seen those. I'm not sure they made it in the pack, but I assume they were distributed to you. And they suggest ongoing, don't grant the variance. And it, as I read them, it's a concern that don't let more construction work occur on the slopes, protect the lake, protect our water. I understand the sentiment, but this is not a question about more work to be done. It's already done, it's in place. And what I would ask you to caution you against doing, because it does happen, we're all prone to it, I think, is we can get a little cynical and we can believe that people act under the belief that forgiveness is easier than permission. So I'm going to do what I want to do. And if you catch me, I'll ask for forgiveness and say, please excuse this. That is not what is going on here. I can tell you that from talking to Randy, what he did, when he did it, and why did he do it. I have no doubt those occasions you're going to confront petitions. That's really what is going on in the background. Whether you can spot it or not, I don't know. But I would caution against the assumption, which I think is too easy to make, that most all people act under that belief that I'll just do what I want and ask for permission after forgiveness after the fact. Mr. Zai is trying to get this cleaned up. Everything is in place. The home's built. It's been there since 2005. There's been this addition, primarily deck and porch type stuff on the back side of it. Those are on stilts. I mean, essentially, it's on piers. So minimal ground disturbing activity to add those. Yes, we had to put the piers in the ground, but minimal ground disturbing activity. The ground was vegetated. I asked Randy about his construction practices, and it was immediate seed and straw of all disturbed soils, not silt screens or straw bales. It was a seed and straw. Immediately, the ground is stabilized. It has been for some period. I think it's 5 years since the last addition to this, if I have my timing right. There would absolutely be more ground disturbing activity to remove than there will be to leave it in place. I don't say that on the belief that, well, gee, let's just excuse what we're on, and once it's done, we just can't do anything about it. As a general proposition, I would disagree with that. I would expect you to, but there are times when the best answer is to do nothing. And I think I would suggest to you this is one of those. It's not an easy answer. It's not rewarding Randy for acting without all the proper permits to do that. He's kind of out of the picture, and that was typically just, if there's going to, whatever has to be done, Ernest is going to do it. Siegel Holdings, Ernest I, he's going to do whatever it is that has to be done. We're asking to make that minimal. The home is there, it's well built, ground stabilized, that the additions here are in the most recent time. Again, required minimal ground disturbing activity. And it is actually a little bit of a problem to knowing what has to be undone, because in 2005, when Randy built the single family structure, the main structure, that predated the buildable area. No variance was required for that, because that buildable area, the 15-degree slope, came in 2015, I believe it was. So you have a split issue in here now that variance would have been required for these additions recently, because they were into that slope area, the deck and the porch you put on the back side. But the basic structure would not have required that variance because it's built before that ordinance existed. And so then we get split results here, and it is a mess. I would ask, consider the best course of action for everything considered, and including the county's interest in protecting the slopes. I do not believe that approving the variances to legitimize what's been done is already in place and stable rewards anybody. I don't believe it becomes a case of, well, others are going to hear about it. It's going to encourage them to do the same thing. I mean, it's, you know, can that happen? Absolutely could happen. I don't have any reason to believe it will. There have been various cases granted before on slope issues, and this board with a little bit different makeup as we've gone through some changes, but this board and a couple of you have done a number of variances on slope and to allow construction. And this, had this come to you first, it would have been presented as a variance need to build a single family home on a legal existing 5-acre lot. And we would have dealt with placement and septic location, all those issues at the time. Those are already done. They're in place. I would ask you to grant the variances to legislate that, to leave the structure in place as is. That does not authorize anything new or additional being done. And it minimizes any issues of ground disturbing activity at this time on how that's going to be accomplished. If you deny the variance, is, I don't know, it's not going to be easy to do. It's not going to be done without some ground disturbing activity. And the last word to say, and I'll be done, because I don't mean this is going to start to sound preachy, but I get concerned in these kind of petitions because I've had to do a number of these over the years and seen some of you several times. And I detect a sense sometimes that it's a feeling that, well, people need to learn what the ordinances are and understand them. And while that may be true, watching the Plan Commission for now 38 years and watching this board less frequently than that, but I'm struck by the number of times that people, long experienced people of this board or the Plan Commission have to inquire the staff and or the attorney of how does this ordinance work and what do we do? What are the requirements? And that's not disparaging anybody. What I'm using that to say is that do not assume that layperson has any more knowledge or skill than what you or Plan Commission members have, who still struggle to understand the full import of the ordinance and how it applies in particular cases. That's not to say ignorance is an excuse and ignorance should be ignored, but it is a reality that people do not necessarily act in defiance of the ordinance when they act without appreciation and understanding of it. So it's not something that it should be punitive, but it is a problem. We have an existing structure. We'd ask that it be allowed to remain as is with no further ground disturbing activity. Thank you.
Thank you, Mr. Farman. Would you mind staying there in case my colleagues have any questions for you? I think Mr. Daly has a question.
I'll try to keep this brief. Planning staff seem to not know the status of the septic.
My understanding
Is that correct? Okay.
That's the same story I was given, that the septic originally, the permitted septic was for the manufactured home that's been decommissioned, that an inquiry is made, and Mr. Zai told me that he was told that they had approval to disconnect it from that structure as being and connect it to the single family home.
I'm sorry. Will you allow me to ask my question?
I'm sorry.
My question is, do you think it's premature to ask for a variance without having a straightforward answer on what's going on with the septic?
I actually do not, because no, I don't. I don't think it's premature. Because if there's a septic issue that cannot be resolved, you're granting the variance amount is not going to, doesn't change that. We still have to deal with the septic and if that. And my understanding is if they've already approved the reconnection, then it's really just a question of size. What are the bedroom counts in the single family home, and is the septic field and system sized appropriately? And if not, then there'd have to be a repair permit to create that. And if you look toward between the structure and the road, there's room and area there, particularly with the manufactured home being decommissioned.
Well, with all due respect, assuming that work needs to happen to the septic, or that would greatly impact the board's decision on whether or not the concerns of the neighbors are in fact valid at this point. You mentioned the damage is done, quote unquote, I'll paraphrase. The home is built, but their concern seems to be the environmental impact. You've pretty much negated that, saying the work is done. Would the septic be an issue whether or not these concerns from neighbors would be back in play?
Well, you're right, there was one comment about the septic of that. That when I read those, I was focusing more on the concerns for construction activity and what it means for the lake and the slope. And then the septic, I separate from that because it's on the other side of the property, stuff on the flatter area. And so if that's a concern, and if one way to answer it is, if the septic can't be resolved as a variance matter anyway, because what you can't have a single family structure there, you don't have a functioning and approved waste system. So if that's something that you believe needs to be answered first, then I think your course should be to table this pending.
I'm throwing it out there for my colleagues to consider. I'm not disagreeing that, and I'm empathizing with the history, and I'm appreciating the work being started prior to the 15-degree ordinance. I'm appreciating all of this. I just want to throw it out there that if there's potential planning concerns that are ongoing that would validate neighbor concerns and have additional environmental impacts, I just want that thrown out there.
Thank you. And Mr. Lockman, do you have any questions for Mr. Parker?
I think he answered them, but let me see if I understood. Mr. Segal built the house. He's left it. It's currently unoccupied, correct?
Yes, right.
And then when he tried to sell it, he found out that there were compliance problems. Mr. Zai, S.I.,
Right.
yeah, Mr. Zai said, well, let me see if I can straighten them out. And that's why you're here.
Yes, because, and they bought the property. He did buy the property from Kim and Randy Segal.
But knowing all the problems.
Right. Yes, he did it with that. And so it is his mission to try to get this straightened up, cleaned up, and then he is on the property. What he'll do with it at some point is, I can offer you a couple of speculations. He gave me a couple options, what he's considering, but it's not to resell it. It's to keep it. Yes. Talking about current owner, Segal Holdings LC, they get this cleaned up, he intends to keep the property. It's not a flip.
Thank you.
Thank you, Mr. Parker. Okay, so, Mr. Carr. I said Mr. Parker, I'm sorry. Okay, so we open this up now to the public. Are there members of the public here who would like to speak in favor of this request for variance? And I'm going to open it up to anybody in the room, online, raise your virtual hand, or on the telephone, please press *9 if you would like to speak in favor of this request. Do you see anyone? Okay, if there is anyone present, either in person, online, or on the telephone, who would like to speak in opposition to this request for variance, please indicate by raising your virtual hand or pressing *9 on your telephone. Okay, there's one person, and in order to unmute, do they press *6? If it's the telephone, or is it Zoom?
Yes, they're unmuted.
Okay, so if the person who is there on, is it Zoom?
Yes.
Okay, if you would please state your name and raise your right hand, and do you swear to tell the truth, the whole truth, and nothing but the truth?
Yes, my name is Ellen Siffin.
Thank you. Thank you, Ms. Siffin. So you have 3 minutes to give a testimony to this request for variance.
Well, my basic question actually is this. I'm sure that most of you sitting there know who Randy Raines was, a health inspector for Monroe County for many years. And we had a conversation once, and he told me that if you build under the log cabin rule, you still have to have a septic permit issued by the Monroe County Health Department. So that's my question. Fine, so you built under the log cabin rule. The property was built on more than 15% slopes, which since the lake is at the end of this road, it's kind of hard to believe that you couldn't figure that out. The watershed was threatened. But irregardless, the question is, for 17 years, was there not a septic permit issued for the house? It was just a septic permit for the trailer?
Ms. Siffin, I don't believe we have the answer to that question. The staff has looked into it and they do not have a firm answer to the question as to whether or not there's a septic system or if there's a septic permit. Is that true, Ms. Casilius?
What we know is that there is a system and that there was some kind of verbal okay that the manufactured home was disconnected and that the existing structure was connected. But as far as I know, we don't have a document, which would not be unusual to have a 20-year-old septic permit and not have that document. That's not unheard of. Moving forward, they would need to provide something.
Okay, so
I understand. Sorry.
I'm sorry, it's unusual that we would ask questions during the testimony of the public, but if you would like to finish your testimony, then and raise the issues you'd like us to address, we would be grateful.
Okay, the only other thing I would say is that the mobile home was also rented. So obviously the mobile home as well as the home was using the same septic. And other than that, what I wrote to you and so forth stands. Thank you very much for your time.
Thank you, Ms. Sippin. Thank you. So according to that testimony, she said that both the mobile home and the house were in use. And so both of them, it's unclear the effluent as far as septic system, how that was managed.
Capacity would be, yes, unknown.
Pardon me?
The capacity of whether the septic system could handle that is unknown.
Yes.
I'm sorry, you burnt in the mic.
The
Capacity is
capacity
unknown.
for the septic system and having both houses connected is unknown if it could have handled that. I do believe there is another caller
Okay.
that has raised their hand.
Oh, yes. If the person could be unmuted and if you would please state your name and raise your right hand, and do you swear to tell the truth, the whole truth, and nothing but the truth?
I do.
And your name, sir?
Kevin Merriman.
Thank you. You have 3 minutes.
I live across the street. I have known the Seagos for decades. Randy's a smart man. I think he's mischaracterized. The house and the trailer were being lived in. Kim and Randy lived in the trailer. Their son lived in the house. I am very concerned that about the house. The house itself, the bottom level is not finished. There are some very unusual design elements incorporated in the house. And so I'm just concerned about the whole situation. I'm concerned about the area behind it. The house sits down off the road. If you're driving down our road, you don't really notice it. So it's somewhere where you could do some work and it wouldn't be really noticed because it's kind of camouflaged by the woods and all, and it sits off by itself. But I think it would be an injustice to allow it to go without making sure the septic system is adequate. That would be my concern, as well as I think that the trailer, I mean, I don't know if can require it to be moved, but I think it just, being there, I think it'll be a temptation to use it again. And I think both these structures have been hooked up to that septic for a while because I know both have been in use simultaneously. And so I just wanted to be able to speak and let you know, as a person that has lived here, that has observed what's gone on, and someone who knows the Seagos personally, that it's just a concern. I'll be disappointed if this variance is allowed. Thank you.
Thank you, Mr. Merriman.
Right.
Okay, I believe we're back to Mr. Carmen. If you have 5 minutes for rebuttal.
Mike Carmen again, thank you. Just a couple of comments. The septic issue has to be addressed, and that is in one sense separate, but I see it is, you connect the two. The other issue, I don't know what purpose it would serve, but I would tell you, removing the deck and the porch area that had been added on the backside would be done with a lot less effort and work and equipment than removing more of the structure. I don't know that it accomplishes anything except, well, it should have been built and therefore we're not going to use the advantage of allowing you to keep it. I mean, it would do that. And so the deck and the porch, if they need to be removed, then they could be removed. That could be done with the least amount of activity. But again, I ask not to have to do that, but that certainly is, I wanted to make sure that was clear. If that could be separated from the structure and removed differently, but I'd rather not. So, and again, I wasn't clear, and it's a little bit hard to hear on the microphone. So to be clear, that the trailer has been modified to remove the kitchen and their other facilities so that it is not suitable to be habited. That was intentional. And so whether it ultimately should just be removed from the lot is a different question. I mean, there's not a plan to do it this time, but that again could be something to be considered. If you felt that was important as a condition of approval, that the trailer just be actually removed from the property, then that's certainly something to do.
Thank you, Mr. Carmen. So we come back to the Board of Zoning Appeals for further discussion and or a motion.
Well, I'm, if there are exceptional cases in which somebody did something in violation of the zoning ordinances without knowing it, I can't see this as one of them. He knows a lot about building and he knows about septic permits, but he doesn't know about planning. I'm sorry, people are responsible to know when they're building, and it does create hardships. It does create problems, but if you comply with the zoning, then you don't have those problems. And I don't see a compelling case to make an exception. So I move to deny variances 2217A and variance to 2217B concerning buildable area from chapter 804 and ECO area 2 from chapter 825.
Is there a second?
I'll second that.
Okay, so there's a motion and a second to deny the Seago buildable area variance to chapter 804 and the Seago eco area 2 variance to chapter 825. A vote in favor is a vote to deny both variances. Skip Daly,
No.
Guy Loftman,
Yes.
Margaret Clemens.
Yes.
Okay, the motion fails 2-1. So this will be continued to the August 3rd Board of Zoning Appeals meeting.
I'd like to make a recommendation that this, perhaps a motion, that the petitioner come back when they have information on the septic. And I would like to even recommend perhaps 60 days from now or something to that effect, and sit down with planning and find a solution. I don't think, I think you need to learn more about where their objections are and find an amicable way to move forward. They're recommending denying you. And if you can't come back with an answer on the septic within reasonable time and let me know and convince me that you're willing to work with them, then I'm gonna side with the other folks as well, but I want to give you time.
With that in mind, I would ask or suggest maybe continue this, not the next meeting, but go 2 months out, just to make sure there's adequate time to address the issues and deal with the septic. So go out 2 meetings if we may, and continue to that one. What's going to be the September meeting?
The
I guess.
September meeting.
That would be to September 7th, Board of Zoning Appeals meeting. Is that
Thank you for your
amenable?
patience
Okay.
tonight. Thank you.
Okay, so that motion or that case is continued to September 7th, 2022 Board of Zoning Appeals meeting.
Okay, thank you. We have one last case, okay? This is VAR 22-18A and B, a servicing requirement variance, and also a variance to condition number 16, outdoor storage screening variance. And that pertains to a property at 2161 North Angelina Lane. And I believe that Mr. Brown will be covering that. Welcome. Thank you.
Thank you. Could I take the time first to just clear up an inconsistency in the agenda?
Yes, please.
Here on this screen, as you can see, it says the owner is Duke Energy. That is a mistake on my part.
Okay.
The owner is BWS Real Estate LLC. My understanding is that they are simply permitting Duke Energy to use this area as a storage facility, as a laydown area for utility poles.
Okay, great.
I apologize for any confusion that this might have caused.
No, it's clear. Thank you for clarifying that and making it clear in the record. We appreciate that. So if you would proceed in presenting this these requests for variances to us, we'd be grateful.
All right. So as you said, that the address of the area is 2161 North Angelina Lane in the Richland Township, section 26. It is 25.7 acres, more or less. And the purpose is going to be a laydown area for steel utility poles, is used by Duke Energy. The petitioner is requesting 2 variances. The first is the surfacing requirement variance for, let's see, I believe it's chapter 806. And number 2 is the condition number 16 outdoor storage screening variance of chapter 802. The petitioner has also already submitted an approved site plan, SIT-22-11, and they are now seeking the variance for that. This is a photo of an aerial image of the site. I don't know if you can see my cursor, but the laydown area would be roughly around here. And that would be the storage area for the utility poles. As you can see, they've already begun preparing the groundwork for the utility area. An element that has come up is whether or not this qualifies as practical difficulties. Practical difficulties are listed in chapter 801 of the zoning ordinance, and they are defined as follows. For variance purposes, practical difficulties mean a significant development limitation that A, arises from conditions on the property that do not generally exist in the area, such as the property conditions create a relatively unique development problem. B, it precludes the development or use of the property in a manner, or to an extent, enjoyed by other conforming properties in the area. C, it cannot be reasonably addressed through the redesign or relocation of development, building, or structures, either existing or proposed. And D, may not be reasonably overcome because of uniquely excessive cost complying with the standard. The first variance is the variance to surfacing requirements, again, chapter 806. And chapter 806 requires it as follows. Off-street parking areas, including parking spaces, aisles, and driveways, shall be constructed using plant mix asphalt, concrete, porous asphalt, porous concrete, or permeable paver systems. Single-family dwelling units, two-family dwelling units, and projects located outside of the urban and designed community areas with off-street parking areas less than 4,000 square feet in size may use crushed stone, porous asphalt, porous concrete, permeable paver systems, and plant mix of asphalt or concrete. The site originally called for a paving using asphalt, and now they are requesting that they be able to use a gravel instead. The purpose of the 806 variance from surfacing is to take advantage of the environmental benefits through reduction of runoff rates, filtering and absorbing oils and debris, as well as that paving would not have an effective life of use with the ongoing egress, ingress, turnabouts, placement of utility poles, and marshaling for utility trucks in the fenced-in area. As the storage area is estimated to be 4 acres more or less and would be used for power poles and vehicle parking. It is subject to surfacing requirement. One interesting wrinkle here is a comment from Kelsey Tatolia. I apologize if I mispronounced that. The MS4 coordinator for the highway department. She wrote that she is satisfied with the attention provided for on-site for this parking area and does not have any concerns about the lot being gravel. But since the gravel surface would still need to be compacted, she sees no difference or enhanced benefit from a detention standpoint. And she requests that if the variance is approved, that they provide some kind of check dam or rock berm to ensure gravel will not wash down the swale to the pond. As for condition number 16, this is in chapter 802, and it states, use shall be conducted within the buildings or structures on the site. Non-agricultural tools, vehicles, and equipment shall be stored so as to not be visible from the street or adjoining property. In addition, storage areas must be screened from view by an appropriate fence or similar enclosure. This variance is essentially asking that a fence not be required for this property, with the purpose being that the approval will not be injurious to the public health, safety, morals, or general welfare of the community. It goes on to say that the laydown area is not at the edge of the property and that there is foliage along the edge of the property that would prevent it from being seen by people adjacent to said property. The laydown area for the utility poles is, again, 4 acres more or less an area. It will require a rough estimate of 1,600 linear feet of fencing. The staff recommends denial of both variance requests. The reasoning being that redesign and redevelopment is a solution, making practical difficulties inapplicable to this request, as well as simply the fact that the petition already has an approved site plan on file for this location that has met all standards.
Do my colleagues have any questions for Mr. Brown?
I do not.
I have one. Is this a temporary storage facility for use for a temporary project that isn't going to be permanent?
That is our understanding, that the Duke laydown has been citing locations throughout the county that are temporary in nature. And so they don't buy the property, they just lease it for a certain time period.
Yes, Mr. Bailey?
This is sounding awfully familiar. Did we not have one that we approved just a matter of 6-8 months ago?
Well, just a reminder, variances are not setting precedent, but
I understand.
there was one on Profile Parkway and it had some environmental conditions associated with the site.
I understand there's no precedence established. Although consistency and good faith is always a good thing. When you recommended denial, did you look at this other situation and weigh the environmental conditions that were placed on there?
I admit I was not aware that a similar variance existed.
But I think staff also recommended denial then. It was-
Yes,
yes.
I'll agree with that.
Yes. So I think there is consistency in terms of your recommendation.
Sure. And
Yeah. But what I don't understand, if I may be just casual and talk like this, is how temporary is this temporariness of these projects? Or is it something that it begins temporary and becomes permanent? Or what do you really, what is the real rest of the story on this?
Yeah, so just two things. One is, I think Daniel did work with Ann, who is our other planner that did the profile parkway variance. So I think that they did communicate a bit about the last case. But the Duke laydown temporary nature, we're not requesting or requiring lease agreements. We don't have that way of enforcing that. So if it lasts 2 years or if it lasts 20 years, we don't really have a way of requiring them to stop the use after we've given site plan approval, which is why we ask them to meet all the standards in the event that, it
and
becomes more
likewise, we
permanent.
can approve a variance for a period of time, correct?
Correct,
Right.
yeah.
Well,
I think in the last
Is-
case, there was a written commitment that the petitioner would abide by all standards in a certain time period, but that was not a condition. It was an agreed upon commitment between.
I
the BZA.
remember some of that and
Yeah.
that weighing in on my decision at least. But is the petitioner even here?
yeah, the petitioner might be here
Um,
online. Mr. Butler here.
Yeah, I see an RC and a Daniel, I think it's Daniel Butler with their hands raised.
Okay, well, if it's okay, I presume that Mr. Butler is the petitioner's representative. Is that right?
Yes, so
So,
would you like Daniel to go first?
Yes, because it's,
Okay.
Mr. Butler, if you would kindly state your name and do you raise your right hand and do you swear to tell the truth, the whole truth and nothing but the truth?
I do.
Thank you. You and the petitioner have 15 minutes combined, so we'd like to hear from you on this case and this request.
Thank you. With me is Jason Fagans. He's the representative on the owner's side. It sounds like you guys have heard this in the past, so I won't give too much background. I just wanted to add that this is really a difficult thing for Duke Energy to come in and try to use this laydown area with asphalt in it. It ruins the asphalt pretty quick with the kind of nature of the laydown area with the kind of poles. They're not going to have vehicles parked in here. It's only for coming in and coming out and having utility poles in there on a regular basis. And it's laying them down and removing them and turning the trucks. It ruins the asphalt pretty quick. So we're asking that they could just use gravel for this purpose, and it's the preferable thing. We are not asking for a variance from the paving from the entire project. We plan to pave 470 feet of the driveway coming into the property so that any dust or anything like that wouldn't be brought into the public right away. So we're not asking for it to pave for the removal of pavement, just in the turnaround lay down area is all we're asking for. I think would be amenable to any type of agreement that you'd think is best in this occasion. But so I'll let Jason talk if you'd like to, or you can ask me any questions.
Okay. I think you mentioned the gentleman you're appearing with, his name is Jason. Does he have his hand raised?
I'm not sure.
RC, if tech services can unmute RC.
RC?
Hi, my name is Ryan Conrad. I'm president of Blackwood. So I'm kind of Jason's surrogate on this part of the call.
Yes, so you're part of the petitioner's team, is that correct?
That's correct.
So would you please raise your right hand and do you swear to tell the truth, the whole truth and nothing but the truth?
Yes, ma'am.
And would you be so kind as to repeat your name because I didn't catch it?
Sure. It's Ryan Conrad.
Okay, Mr. Conrad, if you would continue your request for these variances after following Mr. Butler's lead. I mean, if you have anything to add that would help us to consider these requests, we'd be grateful to hear from you.
Sure. Just kind of broad context. We are Duke Energy's wood recyclers. So Duke Energy has 3 major regions in the U.S. They have a footprint that covers most of Indiana, a region that covers most of the Carolinas, and then a region that covers North Florida. And so we are the exclusive contractor for Duke Energy to recycle all of their scrap wood. So we are in the sustainability and recycling business. So our goal is to keep 90% of all their waste wood, which is mostly poles, out of the landfill. And so we've got big specialized trucks to make that happen. With the advent of electrical vehicles, what the utilities and the government have decided, rightfully so, is we have to expand the capacity of the grid in order to get more green with all the electrical transmission that it's going to take to charge the batteries. So that's what this yard is all about. It is enabling Duke kind of in the short term here to be able to expand out the transmission grid with the rise of electric vehicles. So the intent of this yard is, and it's kind of a new business for us. Like I said, we're wood recyclers, but our equipment is perfectly suited to haul these long steel poles that they'll use to expand the grid. So they asked us if they could use this space as they build out the grid throughout Indiana on a temporary basis and just use it as sort of a distribution yard as they continue in on that work. So that's the broad picture. And to Daniel's point, in terms of the variance for asphalt, when we set up our trucks, they have outriggers, which are kind of like big long legs that help stabilize the truck as we unload these 5,000 pound poles. And so to do that on stone or on gravel, it's easier and it's a lot more sustainable than ripping up your asphalt constantly, and just the industrial footprint that goes along with repairing that asphalt and keeping it up to date. So it just seemed to be overkill. I mean, I'm not a scientist, so I don't know all the ins and outs of the variance and what all that means. But for our purposes, that was the big sustainability impact, is that, the compacted gravel would be fine. We've got a 1 acre, $500,000 retention pond to cover the runoff for that. And so it just seemed proper that we wouldn't need to do the overkill part of asphalting the entire 4 acres to stage the poles.
Well, thank you, Mr. Conrad. And Mr. Butler, did you have anything further? I don't think so. I'm sorry, Mr. Daly has a question for Mr. Conrad.
Mr. Conrad, I am under the impression that this petition is request for a temporary use. And you're leading me to believe that you're in this business and that this will be used on a more permanent basis. Can you address that, please?
That's a good question. And I'm not trying to be evasive here, but I don't really know. I mean, our current interpretation, we don't have some 10 or 20 year agreement with Duke. Our longest term contracts are with regard to our recycling contracts, which is a completely separate thing. For this, it had the feel to us, and they really haven't led us to think otherwise, that it would be more short term. Now, having said that, I don't really know. I mean, that's a bit of speculation on my part, but they're not going to continue the build out of the grid at the pace at which we're going to be doing that nationally over the next 5 years. So our sense of it was, we don't need to buy or build a 50-year solution here. We're just going to accommodate and use our equipment to do this project that is in front of us now.
Okay, are there any other questions for Mr. Conrad?
Well, it seems to me that if electric vehicles are a primary mover of this, that it's a 20-year project to substantially replace the American fleet, and that this build out is going to have to keep pace with that. It seems to me we can't, I don't feel comfortable relying that we're talking about a short term. I don't know that I'd feel differently. It was 2 or 3 years, but it seems to me it's as likely 10 or 20, more likely 10 or 20. And then we're looking at I need to consider this as not a short term, but a long-term use. And so just to make that a question, Mr. Conrad, do you think I'm off base, or do we just not know?
I don't know. I mean, I can't give you a super assertive answer. What I can tell you is there's 2 categories of utility poles. There's the big transmission poles, which basically take power from the power plant.
Mr. Conrad, I'm sorry, you're not quite as clear as you were in your earlier. Can you maybe get closer to the mic?
Sure. Is this any better?
Yeah, I think so.
Okay. So my answer to your question about the longevity is I truly don't know. What I do know is our task for Duke is to temporarily house these transmission poles. So there's 2 different categories of utility poles. There's the big transmission poles, which essentially deliver the power from the plant to town to town to town. So those are the ones you see in the big open fields. The smaller ones are called distribution poles, and those are the poles that are, within the town or within the subdivision or whatever. Our task is to inventory the transmission poles, the big ones. And so in terms of the build out of the grid, that's kind of phase 1, where you're building up the skeleton of the grid to go from the plants to the towns. I would think that's going to be significantly front loaded in the next few years, and that distribution will then be phase 2. But the phase 1 is this transmission poles, and that's what our contract with Duke is with regard to, or these bigger transmission poles.
Thank you, Mr. Conrad.
Can I say one more thing? I'm sorry. Is that all right?
Sure.
The only thing I would say, and maybe it's completely irrelevant in terms of the particulars of the variance or the county policy, but I should have just had a video showing our truck in action and just what it looks like. But it really is no small issue that, the way that we steady our trucks with the big outriggers and the wear and tear, and therefore the upkeep, and therefore just the industrial footprint of the upkeep. I mean, I don't think that's insignificant compared to just gravel. So in terms of the overall sustainability picture and what's best for Monroe County environment, I mean, there seems to be a tremendous advantage with the stone solution versus asphalt.
Well, thank you.
Let me ask
Yes.
a follow-up question. These giant steel transmission poles, or these are these much bigger and much heavier than the used wooden poles that you usually recycle?
They are.
And is that the reason that would your outriggers, would it make any difference whether they were the big transmission poles or just the ones you usually recycle in terms of the damage to the asphalt?
It it is relevant. I mean, for our recycling projects, it's a smaller truck and a smaller, what we call a loader, that, you know, kind of has the claw on the end that's grabbing these poles. So we can get by with kind of smaller assets to do the scrap wood poles, but these longer steel poles, I mean, number one, they're $10,000 a piece. And so you have to handle them with tremendous care versus an old beat up wooden pole that nobody cares about anymore. So to right size the equipment to be able to handle those steel poles, it's a big difference. And so you got big equipment and it's heavy. And again, once you put out those feet or the legs or the outriggers to steady it, it's not an insignificant thing. So it's just, like I said, it will require quite a bit of upkeep for us to do that properly.
Thank you.
Okay, and thank you, Mr. Conrad. And then I'd like to then take questions or testimony from the public, both for and against, and then I have a question for. Okay, so are there members of the public who would like to testify either in favor or in opposition to these requests for variances? If so, please raise your hand on Zoom or press *9 on the telephone.
Going toe to toe with Mike Carmen.
Sorry, that was just some feedback.
Okay, so is there anyone who has raised their hand?
No one has raised their hand.
Okay, so I'd like to ask Mr. Schilling a question, and also Ms. Nestor Jelen and Mr. Brown. In the course of the petitioner's testimony, we re-encountered an issue that we began with tonight, and that was the issue of recycling. And they're recycling wood products, they're recycling metal products, and that isn't anywhere in this zoning, LI zoning code that I see. I don't see a request for variance to that. How does the recycling function at this property impact what we would be deciding tonight?
Well, I guess what you're deciding tonight is the surface only. And whether they're just parking trucks or storing poles on site.
But we became aware of a use that's not permitted within that designated zoning code.
And that would be something for staff to follow up on.
The variances in front of you tonight are for surfacing and outdoor storage screening, so they don't want to add the fencing required around the screening. The use that they applied for was under warehousing and distribution, which is what we classify uses that have a lot of outdoor storage and are taking those storage items off-site and utilizing those. So it's, storing those power poles for a time and then taking them off-site and installing them off-site. So that's the primary use that they were applied for under the site plan.
Okay, is the primary use the recycling or the storage of these steel poles?
It was designated as warehousing and distribution was the use of the
And would
site.
that be the steel poles?
That would be the Duke laydown yard of utilizing the site to store the storage or the utility poles for then later installation off-site.
Yeah, okay.
And you still recommend denial? Correct?
I'm sorry?
And you recommend denial?
Yes.
Okay.
If they put down asphalt and it gets torn up in the first 3 years and they're still doing it, can we go back, can planning go back and say, you've got to maintain that asphalt? Or once it gets torn up, once it's down, we don't do anything, or does anybody do anything to make sure that it is maintained?
So private parking lots that do not comply or do not have adequate servicing, we do not have an enforcement capability or a maintenance schedule for that. So if it does become unmaintained, then it would be on the private property owner to fix that.
So and I'm concentrating here on the surfacing. If we grant the surfacing, deny the surfacing, they proceed, which they might not. But if they proceed and put in an asphalt surface that complies, and if, as they predict, it gets torn up, then whereas gravel would sustain it better, it seems to me we haven't we haven't accomplished much. And as I understand, it's not something fundamental about the site, it's something fundamental about the use. It's the use that's creating the problem. If it was for their normal recycling, it wouldn't be so much of a problem, but you put in these heavy, much heavier steel poles and it becomes a maintenance problem. The scope of our concern is there something special about the site? Not is there. So basically, I guess this would be a use inconsistent with our statutes, but it's permitted. The site plan was approved. So I guess it's one of those things where we're asking somebody to do something that doesn't make sense for them to put in asphalt when gravel would work better, and the drainage people say won't hurt the drainage. Can you set me straight here?
Yeah, so we have received in the past several surfacing variance requirements. And that's typically for heavier industrial uses, like we have a trucking terminal use. Warehousing and distribution has had a few uses. And then there's some other uses that we've had in the past with outdoor storage where they've requested not to have asphalt because it can get damaged by the vehicles or the nature of the use. So there could be an option for the Plan Commission and staff to entertain a text amendment if we felt that in every case of all warehousing and distribution across all of the county, that gravel would be appropriate. Now, in this case, I will point out it's going to be, I think, approximately a 4-acre site that they're going to have as outdoor storage and to be gravel. And so I think the purpose of the ordinance requiring the surfacing is to cut down on the amount of dust that can be emitted based on having gravel. And also note that when you have a gravel lot and you have heavy equipment, it still also requires maintenance and additional gravel from time to time. So either option is not completely maintenance free, but yeah, there are some pros and cons to either.
Yeah, and it's a lot easier to put down another layer of gravel than fix damaged asphalt. Okay, I don't know who, I think I understand the situation about as well as I'm going to. Don't know how that, what that implies for my vote, but I'd be glad to listen to anybody else's thoughts on the subject.
I just would like to ask, since there were no members of the public, is the petitioner entitled to a rebuttal?
That's a good question. Yeah, I don't think so.
Okay.
If there was no comments,
Okay, I
yeah.
just want to make sure I'm following the right process. So,
I'll make a motion.
okay, Mr. Daly.
It seemed like the testimony, second half of that testimony provided more questions than it did answers. And because of that, I'm going to have to rely on the diligence of our planning department. And I'm going to recommend their recommendation, and I'm going to motion for denial.
For denial is what he moved. So I'll second that.
Okay, and that was a motion to deny both the surfacing requirement and the outdoor storage screening. You can vote on them separately. There are two different chapter standards. One is from chapter 806. It would be the asphalt, and then the other one is the fencing.
I will package it, and then if
Okay.
someone has, we'll
Okay.
throw that option out there for.
Okay, so there's been a motion to deny VAR 22-18 and VAR 22-18B. And so one was surfacing requirement to chapter 806, and the other is the outdoor storage screening to chapter 802. A vote in favor is a vote to deny both variances. Guy Loftman,
Yes.
Margaret Clemens,
Yes.
Skip Daly.
Yes.
Okay, so both variances were denied by a vote of 3-0.
Okay. Thank you, Mr. Butler. Thank you, Mr. Conrad. And thank you, staff, for your good work tonight. Do you have any announcements or anything else further to discuss?
I do not have any announcements.
Okay. Mr. Schilling? No. Okay, well, is there a motion to adjourn or any objections to adjourning?
Move we adjourn.
Okay, thank you. Thank you, everyone. Have a good evening.